What does it take to be culpable of a crime? If you're driving down the street and the steering suddenly fails such that your car goes up onto the curb and runs over 5 pedestrians, are you guilty? Somebody pulls a gun and aims it at you. You happen to be carrying your own gun with you. You shoot the individual. Did you commit a crime? You're in the airport returning from a long and sleepless flight. With your brain foggy, you grab a suitcase that looks exactly like yours and start to walk off. Are you guilty of theft? In each of the cases that I described, the answer to the question of whether the individual is guilty or innocent of wrongdoing is, it depends. Take the shooting case, for example. The individual who did the shooting is a police officer, and the individual being shot is a mass shooter. In this case, the individual would likely be innocent of any wrongdoing. Or let's assume that the individual is the mass shooter, and the person the individual is shooting is a police officer. That's obviously different. In the case where the steering failed and the car went up on the sidewalk, did the driver rebuild the car from scrap? And if so, did he put all the parts together correctly? Did the steering happen to fail twice the day before, but harmlessly? But the driver ignored that fact and kept driving the car anyway. As it turns out, whether a person is guilty or innocent of a crime, and if guilty, which crime they are guilty of, depends on what the person was thinking at the time, or in some cases, what the person should have been thinking at the time. It depends on what was going on in the individual's head. It's a state that's called mens rea, or guilty mind. In the early 1960s, the American Law Institute presented a set of definitions for 4 categories of mens rea. An individual can act purposely, knowingly, recklessly, or negligently, or they could be innocent altogether. The first category that we'll look at explains what it is to act purposely or intentionally. According to their definition, quote, a person acts purposely with respect to a material element of an offense when, if the element involves the nature of his conduct or a result thereof, or is his conscious object to engage in conduct of that nature or to cause such a result, and if the element involves the attendant circumstances, if he is aware of the existence of such circumstances or he believes or hopes that they exist. To illustrate this case, let's look at an example, intentional homicide. In this type of case, the accused wanted the victim dead and acted to get what they wanted. The accused may have wanted the victim dead for revenge or to eliminate a rival or to silence a potential witness or just to see somebody die. In any case, the accused wanted the victim dead. Next, we consider the category of acting knowingly. Here's the definition, quote, a person acts knowingly with respect to a material element of an offense when, 1, if the element involves the nature of his conduct or the attendant circumstances, he is aware that his conduct is of that nature or that such circumstances exist. And 2, if the element involves a result of his conduct, he is aware that it is practically certain that his conduct will cause such a result. An example of knowingly killing somebody would be that of an arsonist setting fire to a large occupied building. The arsonist knows that the fire will almost certainly kill people, yet the arsonist isn't trying to kill people, either as an end or as a means to some other end. The arsonist simply is aware of the fact that there are people in the building and that some of them will almost certainly die. Next, we consider what it means to act recklessly. According to the American Law Institute, quote, a person acts recklessly with respect to a material element of an offense when he consciously disregards a substantial and unjustifiable risk that the material element exists or will result from his conduct. The risk must be of such a nature and degree that, considering the nature and purpose of the actor's conduct and the circumstances known to him, its disregard involves a gross deviation from the standard of conduct that a law-abiding person would observe in the actor's situation. End quote. A paradigm example of reckless conduct is recklessness. Reckless driving is driving in a way that the driver knows will increase the risk to others being harmed. racing, speeding, taking one's hands off the wheel, or shutting one's eyes as a way of scaring the passengers. These are all elements of recklessness. If our driver happens to kill somebody, the line between acting recklessly and knowingly isn't clear-cut. It depends on how likely it is that the action will kill somebody else. If the death was certain or nearly certain, then our driver acted knowingly. If it was a substantial and unjustified risk, but less than certain, the conduct was reckless. We should note the provision that the agent must be creating an unjustifiable risk that involves a gross deviation from the standard of conduct that a law-abiding person would observe in the actor's situation. A surgeon who performs surgery that everybody, including the patient, knew carried a high risk of permanent injury or death doesn't act recklessly if the risk can be justified and done with the consent of a fully informed patient. This is typically determined by asking what a normal, law-abiding person would have done in the circumstances. Our fourth and final category involves negligent action. Quote, a person acts negligently with respect to a material element of an offense when he should be aware of a substantial and unjustifiable risk that the material element exists or will result from his conduct. The risk must be of such a nature and degree that the actor's failure to perceive it, considering the nature and purpose of his conduct and the circumstances known to him, involves a gross deviation from the standard of care that a reasonable person would observe in the actor's situation. End quote. Here's an example of negligence. An individual on a movie set picks up a gun. Believing it to be a prop gun and not dangerous, the individual pulls the trigger. It turns out that the gun was real, loaded, and the bullet goes through a wall and kills somebody on the other side. The individual should have known that there was a risk of something like this happening. The individual can be accused of acting negligently. An interesting feature about negligence is that the agent should be aware of a substantial and unjustifiable risk. One can be arrested and imprisoned for a failure to deduce the correct conclusion from the available evidence, or for a failure to search for the relevant evidence. It's often said that everybody has a right to their beliefs, but you don't have a right to believe that pulling a trigger on a gun isn't dangerous if a normally prudent person would not have believed it. And you don't have a right to believe that a sex partner gave consent if a normally prudent person would have had doubts. And you don't have a right to believe that the food that you're serving at a picnic is safe if a reasonable person would have had suspicions. In fact, this is an interesting feature of mens rea, or guilty mind. Some mental states, some beliefs and desires, when they're connected to certain actions in certain ways, determine guilt or innocence. A part of the prosecutor's job is to prove that the accused had the beliefs and the desires or motives necessary for guilt. These provide the criteria for different ranks of culpability according to the American Law Institute. Versions of this list appear wherever there are laws, and this raises a lot of philosophical questions. Among these, whether you are guilty or innocent of a crime, and which crime you're guilty or innocent of, depends on what you believed at the time you committed the act. If you believe one thing, you go to jail. If you believe something else, you go free. How does this square with the right to your beliefs?